Hello Year 11s and welcome to this video on sentencing factors. There are 4 things that you need to do while you're watching this video. The first thing is to take the very best Cornell notes that you can. The second thing is to use the pause and rewind functions. Use the pause function if you need to stop this video so that you can take notes. Use the rewind function if you've missed out on any information and you need to go back over that information. The third thing that you need to do is to have your vocabulary sheet open in front of you so that you can include in it definitions of important terms or of any other words that you're unfamiliar with. And the fourth thing that you need to do is to have your summary books open in front of you. As we go through this video, I will give you some guidance as to what you should include in your summary books. Once you've finished watching and taking notes on this video, make sure that you read the pages from the textbook referred to on this slide. And if you find any additional information in that reading that you think is useful, then please supplement your Cornell notes with that additional information. Well, let's get started then. On this slide, I've set out the learning intention for this video. Make sure that you write this learning intention down in your Cornell notes. This learning intention is that you should be able to explain the factors considered in sentencing, including aggravating factors, mitigating factors, any early guilty plea, and the impact of the offence on any victim. Before we look in detail at these sentencing factors, I want you to remember one very important point. It is the magistrate in the magistrates' court, or the judge in the county court or the trial division of the Supreme Court who makes the decision about the sentence that should be imposed on an accused. If the case against the accused is heard in the magistrates' court, as where the offence is a summary offence, and the accused pleads not guilty, then the magistrate will decide the sentence that is to be imposed on the accused if and only if the magistrate has first decided that the accused is guilty of the offence. However, if the accused pleads guilty to the offence, then there's no need for the magistrate to decide whether or not the accused is guilty because the accused has pleaded guilty. Instead, the only decision that the magistrate needs to make is the sentence to be imposed on the accused. In both of these cases, the magistrate will decide the sentence that is to be imposed on the accused after holding a sentencing hearing, where both the prosecution and the accused make submissions to the magistrate about the sentence that should be imposed on the accused. If the case against the accused is heard in the county court or the trial division of the Supreme Court, as where the offence is an indictable offence, and the accused pleads not guilty, then the judge will decide the sentence that is to be imposed on the accused if and only if the jury has first decided that the accused is guilty of the offence. However, if the accused pleads guilty to the offence, then there's no need for a jury to decide whether or not the accused is guilty because the accused has pleaded guilty. In both of these cases, the judge will decide the sentence that is to be imposed on the accused after holding a sentencing hearing where both the prosecution and the accused make submissions to the judge about the sentence that should be imposed on the accused. Note that a jury never decides the sentence that is to be imposed on an accused. This is solely the role of the judge. On this slide, I will set out the 4 main factors that a magistrate or a judge must consider in sentencing an accused person who has either pleaded guilty or who has pleaded not guilty but is subsequently found to be guilty. These factors, which are set out in the Sentencing Act 1991 of Victoria, are as follows. First, aggravating factors. Second, mitigating factors. Third, any early guilty plea. And fourth, the impact of the offence on any victim. If ever you are given a case study and you're asked to advise on the factors or matters that a court should take into account in sentencing the accused who is referred to in that case study, then you must refer in your analysis to as many of these 4 sentencing factors as are relevant to the case study. Please now include in your summary books the table on this slide and fill in this table as you listen to the information contained in this video. I have set out in this table a description of what you need to include in it. The first sentencing factor is aggravating factors. Aggravating factors are circumstances about the offender, the victim, or the offence that can increase the seriousness of the offence or the offender's culpability, that is, the offender's responsibility, resulting in a more severe sentence. Look down the left-hand side of your vocabulary sheets, find the term aggravating factors, and write this definition in there. In short, aggravating factors are circumstances that result in the offender receiving a more severe sentence. There are a number of circumstances that may be aggravating factors, and I've set out some examples of these below. It will be an aggravating factor if the offender uses violence, explosives, or weapons in the course of committing the offence. For example, as where the offender uses a gun to rob a bank. The nature and gravity of the offence may be an aggravating factor. This will be the case if the offence is cruel, for example, as where the offender deliberately gouges the victim's eye out with a knife during an assault, or where the offence is unprovoked, for example, as where the offender attacks the victim for no reason, or where the offence is pre-planned, for example, as where the offender is a contract killer who is paid to kill the victim. The vulnerability of the victim may also be an aggravating factor. Sadly, there have been a number of recent cases where disabled people have been sexually assaulted by their carers, where children have been sexually assaulted by priests or teachers or scoutmasters, and where elderly people in aged care facilities have been sexually assaulted by the nursing staff. The vulnerable nature of the victims in these cases will result in the offender receiving a more severe sentence. It will be an aggravating factor if the offence is motivated by hatred for or prejudice against a particular group of people. An example is where the offender deliberately targets other people for assault because, for example, they are Asian, or because they're Muslims, or because they are same-sex attracted. It will be an aggravating factor if the offence occurs in front of or is seen by children. This is because children are more likely than adults to be traumatized where they witness an offence. It will be an aggravating factor if the offence involves a breach of trust. An example is where a doctor who has care of a patient unnecessarily touches that patient in a sexual manner while conducting a medical examination on that patient. And finally, it'll be an aggravating factor if the offence occurs while the offender is on a community correction order or bail. The second sentencing factor is mitigating factors. Mitigating factors are circumstances about the offender, the victim, or the offence that can reduce the seriousness of the offence or the offender's culpability, that is, the offender's responsibility, resulting in a less severe sentence. Look down the left-hand side of your vocabulary sheets, find the term mitigating factors, and write this definition in there. You can see that this definition looks similar to the definition of aggravating factors, except that, in the case of mitigating factors, these are circumstances that result in the offender receiving a less severe sentence rather than a more severe sentence. There are a number of circumstances that may be mitigating factors, and I've set out some examples of these below. It will be a mitigating factor if the offender is provoked by the victim, for example, as where in an assault case the victim calls the offender names or punches the offender, and only then does the offender retaliate by hitting the victim. It will be a mitigating factor if the offender shows remorse, for example, as where in a case of reckless driving causing serious injury, the offender stops the car once they realise they have hit the victim and they get out and try to help the victim. It will be a mitigating factor if the offender has no previous criminal convictions, that is, they don't have a criminal record, or if the offender has cooperated with the police. It will be a mitigating factor if the offender has shown efforts towards rehabilitating themselves or otherwise has good prospects of rehabilitation. For example, as where the offender has been a very good student at school by perhaps completing their homework on time, and that shows that they've got the ability to make something good out of their lives. It will be a mitigating factor if the offender is under personal strain or stress at the time they commit the offence. For example, as where in a theft case, an employee has stolen money from their employer to pay their outstanding mortgage payments so as to avoid the bank repossessing their house and selling it. And finally, it will be a mitigating factor if the offender is young or disabled and so is not fully aware of the consequences of the offence. Teenagers will often not have the self-restraint and discipline that older, more mature people are expected to have, and so typically teenagers will receive a less severe sentence than an older person for the same offence. The third sentencing factor is whether the offender has made an early guilty plea, that is, whether the offender has pleaded guilty before the trial. An offender who makes an early guilty plea will typically receive a reduced or discounted sentence. This is for three reasons. First, an early guilty plea avoids the need for a trial and therefore frees up the time and resources of the court to deal with other cases. Second, an early guilty plea avoids the stress of a trial for the victim. In particular, it means that the victim is not forced to relive the offence by giving evidence at the offender's trial. And third, an early guilty plea shows that the accused is taking responsibility for their actions. If a judge or magistrate decides to discount an offender's sentence because of an early guilty plea, then the judge or magistrate must say what that discount is, where the sentence which is given to the offender is either imprisonment or a fine of more than 10 penalty units. The fourth and final sentencing factor is the impact of the offence on any victim. An offence may have a range of different impacts on a victim. For example, if the offender has broken into the victim's house and assaulted the victim, then the victim may have suffered physical injury, such as broken bones, as well as psychological injury, such as a fear of being home alone because they are worried that someone else will break into their house and assault them. And if the offence is one of theft, then the victim will have suffered a financial loss, that is, the loss of the money or other property that the offender has stolen. The way in which a magistrate or judge is made aware of the impact of the offence on a victim is through a victim impact statement. A victim impact statement is a statement that includes particulars of the injury, loss, or damage that is suffered by the victim as a direct result of the offence, and may include medical or psychological reports on the victim that substantiate the impact that the offence has had on the victim. Look down the left-hand side of your vocabulary sheets, find the term victim impact statement, and write this definition in there. It is important to remember that a victim may not just be the person against whom the offence has been committed. For example, in a murder case, the victims may include the members of the deceased person's family, such as their partner and their children, and so each of these people will be able to provide the court with a victim impact statement. This is because these people will also have been directly impacted by the offence. For instance, the members of the deceased person's family will suffer grief from the loss of a partner and a parent, as well as the loss of any financial support provided by the deceased where the deceased earned money for the family. The more serious the impact of the offence on any victim, the more severe the offender's sentence is likely to be. Typically, a victim impact statement will be read out to the court by the victim or a support person at the offender's sentencing hearing. Most importantly, however, victim impact statements are not used to prove the guilt of the accused at their trial. That is, they are not used to decide the verdict. Indeed, victim impact statements are only given to the court after the accused has pleaded guilty or been found to be guilty. The only use that is made of victim impact statements is to determine the sentence that is to be imposed on the offender. As I've said, the more serious the impact of the offence on any victim, the more severe the offender's sentence is likely to be. So never refer to victim impact statements as evidence, and never refer to victim impact statements as being used in the trial to decide the verdict or prove the guilt of the accused. Well, that brings us to the end of this video on sentencing factors. As a result of watching and taking notes on this video, you should now be able to explain the factors considered in sentencing, including aggravating factors, mitigating factors, any early guilty plea, and the impact of the offence on any victim. Don't forget to read the pages from the textbook referred to on the first slide. And if you find any useful additional information from that reading, then supplement your Cornell notes with that additional information. Thank you very much for your attention.